Here is the question that just got answered by the highest court in this country, with 9 votes and 0 disagreement. If you are legally carrying a firearm in your vehicle valid permit, registered gun, clean record, nothing wrong, does the presence of that firearm alone give a law enforcement officer the legal authority to search your car? 9 Supreme Court justices just answered that question, and the answer, unanimous, unambiguous, and with more legal weight behind it than any Second Amendment decision in a generation, is no, it does not. A legal firearm in your vehicle is not probable cause. It never was. And the court just made sure every lower court in this country knows it. If you carry a gun in your car, or if you know someone who does, the next 12 minutes are going to change how you think about every traffic stop for the rest of your life. Not because of what the ruling says, because of what it does not cover, and because of the one moment at every traffic stop where this ruling stops protecting you and you will not even realize it is happening until it is already too late. Subscribe to this channel right now and turn on the bell. I built this community for one reason, so that when the Supreme Court issues a ruling that directly affects how you exercise your constitutional rights, you hear about it in plain language before you need it, not after. The people subscribed here understood this ruling before their next drive. Subscribe now and let us get into every word of it. Before we go any further, I want to know something real. Have you ever been in a situation, a traffic stop, a parking lot, any interaction with law enforcement where you were carrying legally and felt genuinely uncertain about what your rights were in that moment? Drop yes or no in the comments below. Because what I am about to tell you is specifically for the person who answered yes and for the person who answered no but has never actually thought it through. The Second Amendment gives you the right to keep and bear arms. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. These two rights are supposed to coexist. They were written into the same document by the same people who understood that a free citizen needed both simultaneously the right to be armed and the right to be left alone when they had done nothing wrong. For most of American history, that coexistence was not seriously questioned. Then something started shifting in lower courts across the country. Judges in multiple jurisdictions began accepting an argument from law enforcement that went like this. Firearms are dangerous by nature. A firearm in a vehicle creates an inherently dangerous situation. That dangerous situation gives an officer reasonable justification to search the vehicle regardless of whether the firearm is legal and regardless of whether any other indication of criminal activity exists. On its surface, that reasoning sounds protective. Follow it one step further and it becomes something very different. If a legal firearm in your car automatically justifies a search of your car, then carrying legally strips you of your privacy rights every single time you get behind the wheel. Your Second Amendment right becomes the mechanism that defeats your Fourth Amendment right. You cannot exercise one without surrendering the other. That is not a constitutional republic. That is a false choice dressed up in legal language. And it was spreading through real courtrooms affecting real gun owners until a case came along that the Supreme Court could not leave unanswered. The facts of that case were simple, and that simplicity is exactly what made the court's response so clear. A driver was pulled over for a routine traffic violation. He was calm, cooperative, and legally armed. He disclosed the firearm voluntarily. The officer searched the vehicle anyway, pointing to the firearm as justification. No other suspicious behavior. No odor. No inconsistent statements. No erratic movements. Just a legal gun and an officer who believed that was enough. The driver objected. The search happened. The lower court agreed with the officer, and then 9 Supreme Court justices looked at that situation together. 9 justices. Every corner of that bench ideologically. 9 people who rarely agree on anything involving firearms and law enforcement authority, and they voted the same way. 9-0. Not 8-1. Not 7-2. Not a narrow majority with a carefully worded dissent, creating wiggle room for lower courts to reinterpret. 9-0, with language that was precise, direct, and deliberately difficult to misread. The mere presence of a legally possessed firearm in a vehicle does not, by itself, constitute probable cause to search that vehicle. By itself. That phrase is doing the most important legal work in this entire ruling, and I am going to explain exactly why in a moment. Drop a comment right now telling me which of these two things surprises you more. That lower courts were actually letting officers search vehicles based on a legal gun alone, or that it took a Supreme Court case to stop it. Tell me which one, and tell me why. Because your answer tells me something important about how most people understand their constitutional rights before they need them. Now here is the part most channels skip entirely. This ruling is real. It is significant. It is one of the most important Second Amendment decisions in decades. And it will fail you completely if you misunderstand what the two words by itself actually mean. The court did not say a firearm in a vehicle can never be part of a probable cause analysis. It said a firearm in a vehicle cannot be the only factor. The moment other factors enter the picture, the legal calculation changes immediately, and it changes in the officer's favor. 3 specific situations make this ruling irrelevant to your case. Know all 3. If you are legally prohibited from possessing a firearm, this ruling protects you exactly as much as the Second Amendment does, which is to say, not at all. A prior felony, a disqualifying domestic matter, any prohibiting factor means the gun in your vehicle is not a neutral fact. It is evidence of a crime. And an officer who has any reasonable basis to suspect unlawful possession does not need the gun plus other factors. The suspicion of unlawful possession is the probable cause. If your state has specific firearm storage requirements inside a vehicle and your firearm violates them, an officer who can observe that violation is not searching because of the gun. He is searching because of a specific articulable violation of a specific state statute. The distinction sounds technical. The practical difference is enormous. Know exactly how your state requires a firearm to be stored in a vehicle before you drive with one. Unloaded or loaded. Locked container or accessible. Specific area of the vehicle or unrestricted. This varies significantly by state, and getting it wrong hands an officer a justification that 9 Supreme Court justices cannot take away from him. If the firearm is one of several factors, not the only factor, the ruling does not block the search. A passenger behaving inconsistently, an odor of a controlled substance, your own statements, creating contradictions, any of these combined with the presence of a firearm can satisfy a probable cause standard even under this ruling. The court stopped the firearm from being the whole story. It did not stop the firearm from being part of a larger story that adds up to probable cause. Now here is what I consider the most important 60 seconds of this entire video. Because this is the moment where more responsible, law-abiding gun owners lose their constitutional protection than any other, and it happens in the most ordinary and unsuspecting way possible. The officer has run your information. He knows you are clean. He can see the firearm is likely legal. He knows he does not have enough under this ruling to justify a search. And he says something like this: I understand you have a firearm, and I just want to make sure everything is safe for both of us. Would you be comfortable letting me take a look through the vehicle? Maybe 30 seconds and we are both on our way. He sounds professional. He sounds reasonable. Every cooperative bone in your body says yes. You want to prove you have nothing to hide. You want the interaction to end. You want to be the responsible gun owner who makes things easy. Do not say yes. One word ends this ruling's relevance to your situation permanently. The moment you say sure, the moment you nod, the moment you say go ahead, consent overrides everything. The glove box, the trunk, your personal bags, all of it. And no attorney, no ruling, no 9-0 vote can undo a voluntary consent in any courtroom in this country. The ruling is a wall between you and an unlawful search. Consent is the door in that wall that you open yourself. Once it is open, it cannot be closed. Here is the protocol that keeps that door shut. 8 steps. Learn them in order. Pull over immediately and correctly the moment you see the lights. Signal, slow, right shoulder, no hesitation. How you respond in the first 10 seconds sets the tone for everything that follows. Before the officer reaches your window, create the safest possible environment. Engine off, both windows fully down. Dome light on at night. Both hands on top of the steering wheel. Do not move them for any reason until the officer is standing at your door. Speak before you reach for anything. Tell the officer you have a legally owned firearm in the vehicle and ask how they would like you to proceed. Do not reach toward the glove box or center console unannounced under any circumstances. That sentence protects you and the officer simultaneously. Know your state's disclosure law before you ever need it. Some states require you to inform the officer immediately. Some do not. If your state requires it, comply without elaboration. If you are directly asked whether there is a firearm in the vehicle, answer honestly. A lie to an officer converts a traffic stop into something far worse than any other outcome you are trying to avoid. Refuse consent with 3 words or fewer. You do not consent. No argument, no explanation, no citation of any court ruling. If the response is that you should not mind if you have nothing to hide, do not take the bait. That is a pressure tactic, not a legal argument. Respond once, then stop speaking. Use silence as the tool it legally is. You have a Fifth Amendment right to remain silent, and it applies at a traffic stop. Do not volunteer information. Do not fill quiet moments with nervous talk. Most searches begin with something the driver said that they did not have to say. If a search proceeds after you have clearly refused consent, state once for the record, and for any camera present, that you do not consent. Then stop. Do not physically interfere. The officer's decision to search after a clear refusal becomes the legal story your attorney uses in court. Your composure in that moment is not surrender. It is strategy. Document everything the moment the stop concludes. Time, location, officer name and badge number. Every word spoken, whether consent was given or refused. What justification was stated for any search. What was found or not found. Write it down before you drive 5 miles. Specific contemporaneous notes are the foundation of every case that gets won. Vague recollections from 3 days later are the foundation of every case that does not. The Supreme Court just said something that should matter to every person who carries a firearm in a vehicle in this country. Legal gun ownership is not suspicion. Responsible carry is not probable cause. Armed does not mean criminal. 9-0 is about as clear as the highest court in this land ever speaks. But that clarity only protects you when you understand exactly where the protection starts, exactly where it ends, and exactly what to say and what not to say when a polite professional voice asks you for permission to make it irrelevant. Subscribe. Share this with someone you know who carries in their vehicle. Because knowing your rights after something has already gone wrong is the most expensive way to learn them. I will see you in the next one.